Hey, it's Val, and in this video I am going to share with you the benefits of having an ethical business practice for the modern divorce lawyer. And so why do we want to talk about the benefits of having an ethical practice, an ethical business associated with your law practice? Well, the thing is that when you run your practice on an ethical basis, when you apply ethical business principles to your law practice, it is not only going to, make you feel good about it, it's also going to reduce your stress, keep your clients happier, and it's also going to improve your bottom line. That is, make you more profitable. So what could be better than that? Not a lot, right? And the thing is that what's really changed over the last 30 years or so that I first became kind of involved or aware about law at all, when I started law school and then articled and became a lawyer, is that legal landscape has changed immensely. And so how has it changed? Well, what it means to have an ethical business practice, what it means to be an ethical divorce lawyer has changed drastically. And as I am sharing this with you, and you're going to want to stick around to the end of this video because I'm going to tell you the story about someone I will call Aggressive Arnold. Aggressive Arnold has been a lawyer for a very, very long time. And over the years, as you know, in his heyday, which started more than 30 years ago, he was considered a very ethical lawyer, absolutely straight and narrow. However, when I'm sharing this story about Aggressive Arnold, you will see how what it means to be ethical, what being ethical means, has changed over the years. Now, let me talk about Aggressive Arnold. Okay, Aggressive Arnold, he's one of those old boy, traditional type lawyers. And he had a practice where if people would come to see him, he would absolutely 100% start an action against the other party, so that would be the other party's former spouse. He would throw everything and the kitchen sink at this person in the legal action. He would, ask, sole custody of the kids, would not want to have to pay support. It just went on and on and on. The thing is, what made Aggressive Arnold ethical in his day is that, he was absolutely clear with his clients about how much he would charge them. Very clear about his billings. He never padded his fees. So a lot of lawyers, what they'll do is they'll add another 0.2 or 0.4 or 0.5 or 3 hours, and without actually having done the actual work. Well, Aggressive Arnold was absolutely pristine in that if he spent 36 minutes on a matter, but not 46, he would only bill the 36 minutes. He was absolutely very, very dedicated to being honest. In fact, he had his own ways of being ethical too. I recall a situation where he's sitting in court and he's representing a client who actually doesn't have a lot of money compared to his other clients who, have a lot of money. And what he did in this particular case is that instead of just sitting there and watching other matters that were going ahead, it was a chambers day, other matters going ahead before him and charging his client for his waiting time, he in fact sat and worked on another file while he was waiting to ensure that he wasn't billing that client of his for his time waiting in court. Now, that was a really ethical thing to do. He was also super ethical in that when he took his clients to court, he was 100% prepared all the time. In fact, he would do more exhaustive research than his opponent virtually every time. He knew the rules of court inside out and backwards, and he also knew the law associated with the rules. So he really knew what he was talking about. He also always showed up on time for everything. So there were some really great things that he did. However, as the years went by, Aggressive Arnold's reputation started to sully. How did it get sullied? He became known as the town bully. People thought he was a terrible bully. His colleagues thought that, his clients thought that, courts thought that, the clerks, the judges, they thought, He's such a bully. And they didn't really like that because they felt so much of his aggressive nature, because you could often hear him yelling at other lawyers, yelling at, yelling at his clients if he was upset with them inside his office, in the courtroom. And people thought, well, is that really necessary, that aggressive approach? He also had a reputation for what we'd call the scorched earth policy. And what do I mean by that? Well, what I mean by that is that, well, he would bring so many of his cases to trial. He brought so many. So where other lawyers might be able to negotiate a resolution, he was always dragging, not every time, but most of the time, dragging his clients to court proceedings, causing huge emotional stress, huge turmoil, huge financial consequences. And of course, when people were parents, of course, they would never have a chance of being able to co-parent peacefully going forward, particularly after they'd gone to this huge war in the courtroom. As well, what started happening is lots of lawyers wouldn't even take files against aggressive Arnold. They said, it's not worth it to me. I don't like how he talks to me or communicates with me as opposing counsel, and I don't like how he talks to my clients. I'm not putting my client through that. I'm not going through that. And so lawyers wouldn't even agree to take on files where he was on the other side. And a lot of the lawyers who did agree to take files on where he was on the other side, well, they wouldn't pick up the phone and talk to him. They were too afraid to do that. They would only communicate with him in writing because he was so aggressive in his communications. It sounds like he got a lot of work, right? Yes, he did. Sounds like, he had no end of, hey, you want an aggressive lawyer, you got to hire aggressive Arnold. And he had that reputation. But let's think about what aggressive Arnold's life was like. Well, here's the thing. He was stressed out all the time. Because he was always so combative with other people in the office, outside the office, in the courtroom, outside the courtroom, with other lawyers, with everyone. What ended up happening is he's like living in a cortisol bath like all the time. And he wasn't a very happy person as a result. He's completely stressed out. Oh yeah, and not to mention, he worked long hours. He always had another fight coming down the pipe. And because of that, he worked every single weekend, took very few holidays, and worked really long days. So I wonder, how happy was aggressive Arnold when he was going through this situation? I don't think he was that happy even during his heyday. But the thing about aggressive Arnold, he's a smart guy. And I'm going to share a little bit later on in this video at the end to tell you about where aggressive Arnold is now. Well, now compared to aggressive Arnold's heyday, well, things have changed a lot in the legal landscape, culturally, legally, technologically. And well, here are some of the changes. First of all, I don't know about you, but I don't think families belong in courtrooms. They really don't. And there has been a great focus, a tremendous focus by legal advocates everywhere that we keep families out of the courtroom.
Oh, hey, it's me. Interrupting a little bit because I want videos like this to reach more people. So if you are enjoying what you see, if you're finding it helpful, please hit the subscribe button, which is somewhere up there. And also tell me, what was the biggest takeaway you had with respect to this video? Leave it in the comments below and I will answer every comment, every question, because that's what I do.
How we do that is we engage in dispute resolution processes like mediation, four-way meetings, mediation arbitration, negotiation with counsel. Lawyers are now more and more trained and take extra training so that they have dispute resolution skills. And when they have those skills, guess what they do? They keep their families, the families that they work for, out of courtrooms. And of course, that saves their clients emotional stress, emotional turmoil, makes them happier with the work their lawyer does, and it goes on and on. The second thing that's really changed over the last 30 years is there's much more emphasis on kids coming first. I know in my jurisdiction, we've moved away from a mom's rights or dad's rights model to a responsibilities model, mom's responsibilities, dad's responsibilities, whatever parents' responsibilities, as well as in understanding that when parents are in court fighting, that impacts the kids. Even if parents are doing everything they can to shield their kids from the fact that they're in court, well, the thing is that kids, they pick up on mom or dad when they're completely stressed out financially, emotionally, or that they're in turmoil. And so the thing that lawyers often focus on, and we have a much greater emphasis towards, is ensuring that, well, hang on, if parents going to court really impacts kids negatively, how about we avoid the court thing altogether and get a binding final settlement agreement by avoiding court at the same time. Another thing that's really changed over the last 30 years is that there is a much greater awareness of the impact of family violence. In aggressive Arnold's day, it would be highly likely that the person who was, well, doing the family violence would be able to continue to get to bully and cause their spouse grief post-separation vis-a-vis the litigation process. In my jurisdiction, family violence is taken so seriously that in order to even mediate a matter, qualified mediators must screen for family violence to understand and ensure that if there was family violence in the relationship, how that family violence will have impact the negotiation process. Really great stuff. Another thing that's really changed over the years, at least since I first started practicing, my gosh, when I first started practicing, I didn't even have a computer on my desk. Can you imagine? It wasn't even a thing. And technology. We have a lot more access to technology that makes our law practices more streamlined, that makes information for our clients more readily available, that makes, we still had faxes back then, but wow, all our letters were printed off. We had these big, huge, fat, files with it was just a lot to keep track of. And now we have so much more technology that really benefits and streamlines stuff for us in terms of running our practice, but also client service. It's been huge. Another thing that's really changed in the last 30 years or so is the financial cost of litigation. Now, back in the olden days, I say when I was a baby lawyer, well, getting divorced, well, it was just kind of like it was part of it. You're gonna have to pay for some litigation. Well, that's just, eventually people are going, wait a second. Why do I want to line the pockets of my divorce lawyer? Why can't I just get through this process on an amicable basis, if possible, and keep more of my hard-earned resources for myself and my children and my future rather than lining, the pockets of my divorce lawyer? And the thing is that because of that, people are much more savvy about avoiding litigation. Another thing that's really changed, of course, is that the emotional cost of litigating is much more understood. Going to court is stressful. It's stressful for the litigants. It's expensive for them. It's very tumultuous. And guess what? It's stressful for us too, the lawyers. So, the thing is that why wouldn't we want to skip that whole thing if we can? The other thing that's really changed over the last 30 years is that there's much more of a focus on, our clients' mental health, what we know and pay attention to a lot more. Sure, we'd say, people are going through a divorce, it's a hard time, whatever. Well, now we really are aware of that the stress and impact of a separation and divorce itself, the grief associated with it, the turmoil that can cause, even if it goes relatively smoothly, is huge. And in the legal arena, we are much more aware of that. We're also more likely to refer our clients to, let's say, if they're having trouble co-parenting, sending our clients to a co-parenting coach or a parenting expert. So taking into account all those changes that have happened in the legal landscape over the last 30 years, let's talk about the benefits of having ethical business practices for your divorce practice. First of all, if you have dispute resolution training, that's going to help you be a better negotiator, better lawyer. You're going to avoid court more often. Your clients are going to love you a lot more. If you are organized with your practice and streamlined your processes and you are very efficient about the kind of how you represent your clients and putting their needs first, it's just so great for them. And so the benefit, again, is that you turn your clients into these raving fans while you are also less stressed out yourself with a better bottom line. Yay! So here are just some of the benefits of having an ethical business practice for your law practice? Well, first of all, because you put your clients' needs first and are client-centered in terms of what they need, what's important to them, because you understand that because of your dispute resolution training, you are going to be able to deliver, and also because you have a really organized practice, you are going to be able to deliver really high quality representation each and every time you represent someone. Because you do your best to stay out of the courtroom, but still get your client matters to resolution that are fair, that are economical, that make a lot of sense, your clients will turn into raving fans and they will refer their friends and loved ones to you when they're going through a separation or divorce. They won't hesitate to leave you a really positive Google review. They will really want to support your success so that you can help more people. And because you're known as an ethical lawyer who is ethical in today's landscape, you will really reduce the likelihood of complaints to your governing body, that is your law society or bar, from other lawyers, your previous disgruntled clients, or parties on the other side. And let's face it, having discipline proceedings or the fear of discipline proceedings with our governing bodies is stressful stuff. So it's a huge benefit to avoid that stressful stuff. And because you have leveraged technology and use it to its best possibility, you again, well, you're going to provide that really high level of service, the really high level of client care. One of my mentors says is what you do is you automate the stuff that can be so that you can do the excellent work, so that you can work in your zone of genius. And your clients will see that and they'll benefit from it and they'll really like it. And well, it'll be more pleasant for you too. And overall for you, you're just going to be a lot happier and a ton less stressed out. Are you wondering whatever happened to Aggressive Arnold? Well, you know, remember how I said he was a really smart guy? The cool thing about Aggressive Arnold is he got with the program. Aggressive Arnold is now actually a chartered mediator. He qualified to become a mediator himself, and he mediates matters as a mediator. He brings clients to mediations. Sure, he still can be a total grumpy Gus at times. However, he got with the program, and his clients are benefiting from it, and he's benefiting from it, and his bottom line's benefiting from it. This is Val. Much, much love.
If you found this video helpful, and I hope you did, please give it a thumbs up. Because if you do that, then this video will be able to reach more people. And as well, if you want to stay in closer touch with me, please ring the little bell icon so that you can subscribe to this channel. This is Val. Much, much love.